rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. What is the time set for oral argument in cause number 1CA CV180296? Yvonne Book. In the matter of Yvonne Book, Bruce Rigelsberger, Kevin O'Connell Trust, Bart V. Wiles, the plaintiff, appellees, cross appellants, Gordon Keith Jones, defendants, appellants, cross appellees. For everybody's information, these proceedings are being recorded, both audio and video. So barring any unforeseen problems, not that that could ever happen, you can critique yourself on YouTube in a couple of weeks. Counsel for each side will be entitled to 20 minutes. Today we have the, not anomaly really, but we have the complication of the cross appeal to be argued. And so to the appellee, I would say that when you go to the podium to speak, we'll expect you to address your cross appeal at that time. Is that correct? And you will be responding during your reply time with your answer to that. And we will allow you to come forward and do your reply on the cross appeal, okay? So we're all on the same page. Thank you. So you will be getting the 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And for the appellant, if you wish to reserve any portion, you're going to have to do that within the confines of the cross appeal and those issues, but it will still be the 20 minutes. We have reviewed the briefs, both as to the appeal and the cross appeal, and conferenced the case, so we are well aware of the facts and issues attendant to the argument, particularly in a case that has both the appeal and the cross appeal. You're going to want to be judicious about the time, how you use your time. So how you use that time, just understand that we have reviewed the briefs and discussed the matter even this morning. Counsel, when you each come to the podium, I would ask that you state your name for the record and who you represent. And with that, the podium's yours. Oh, wait a minute. I know you can count. There are 2 judges here and not 3. This panel includes not just Judge Thum and myself, but also Maria Elena Cruz, Judge Maria Elena Cruz, who could not be here today. She has read the briefs. She has conferenced with us in regard to this matter earlier. She will be reviewing the video and will be rendering her decision in regard to this matter once she gets back, based upon the not just the briefs, but also the content of the YouTube video. Okay? You understand? I mean, are we all on the same page on that? There will be a 3-judge panel hearing and deciding the matter. Judge Cruz could not be available for today. Okay? Anybody got any questions about that? Good deal. Thank you. It's yours.
Good morning, Your Honors. May it please the Court. My name is Stephen Kubashevsky. I represent Gordon Keith Jones, and the Kevin O'Connell Trust in the 2014 matter that is brought before this Court with regard to a petition that was originally filed by my clients for the enforcement of a settlement agreement that was dated November 20th, 2014. So we're here with regard to a decision that was rendered by Judge Klein with regards to that settlement agreement. The settlement agreement is very important, as is the caption of the case, as is the service of process, as is the parties who were present and the bundles of rights that each of those parties maintained prior to the time when they entered into the settlement agreement. So if you look at the original complaint that was filed back in 2014, and then you look at the complaint that was filed in 2015, the pleadings are very clear that were filed on our behalf or on the behalf of the parties that I represent, that a lot of the claims are identical. You can cross-reference those. Those have been cross-referenced in both of the matters. So when you look at the bundles of rights that are held, you have beneficiaries, you have contingent beneficiaries, you have individual defendants, and then you have the defendant, which is in question primarily here today, which is the Kevin O'Connell Trust. So in 2014, who holds each of those bundles of rights as they stand before Judge Klein at a settlement conference? So if you have a trust, and this is all fairly well pled, a trust can't individually be a party, isn't somebody that can individually accept service. If we use this document here as an example of the trust, I say, Mr. Trust, if you would stand and be sworn. The trust can't stand up and be sworn. You say, Mr. Trust, if you would walk over to Mr. Rudisell, hit him in the foot with a hammer. The trust isn't going to do anything. The trust has to be sued and has to sue in relations to the trustees that are currently serving in the capacity as the trustee. In the 2014...
Or are you suggesting that if co-counsel is to be hit in the foot, not only do you have to give a person the hammer, but you have to tell them that when you go over and hit him in that foot, you've got to declare that you're doing it as a trustee?
Well, it's irrelevant as to whether or not you're doing it as a trustee, because they would have personal liabilities if they did so for assault and battery.
I'm using your example.
Okay.
Put it in the context of this case.
Put it in context of this case. They would have discretion about whether or not and they would have a balancing test the trustee would have to undergo with regard to the costs and benefits that would have to be analyzed as to whether or not that would be an appropriate action.
Wait a minute.
So that's...
Wait a minute. Is that a before the action discussion
Absolutely.
to be had, or is that an after the action discussion?
It's a before the action has taken place. So you have to identify what's appropriate for the trust, for all the beneficiaries that are involved. What's an appropriate action for this trustee to take on behalf of this trust who's serving in that capacity on the day that you stand in front of Judge Klein on November 20th, 2014. So when you look at the bundles of rights that are being held, my client, and I think you probably garnered this from the brief, but his father has passed away. So in 2014, it was his father, Gordon Jones, and my client, Gordon Keith Jones, so I'll refer to him as Keith, that held the entire bundle of rights for them in their personal capacities and for them in the capacity as trustee of the trust. So if they're not present, the court would have no jurisdiction to enter any agreements with regard to the trust. And so I'm going to address that here in a second.
If let's be real clear, if who was not present or what was not present.
If the trust was not present at the time on November 20th, 2014, the court would have no jurisdiction to enter any orders with respect to the trust.
And if the trust agreed to certain specific provisions of, I'm trying to track exactly the way you said that. If there are going to be matters involving the trust, and the trust and certain issues are going to be conceded that impact the trust, the trustees would need to be there to do that. Is that correct?
That's absolutely correct, Judge.
So if a settlement agreement is entered and the settlement agreement impacts the trust,
In any way, shape, or form.
then it would have to be,
Present.
as an absolute matter of law, the trust would have to be present through its trustees who had the authority to settle and engage in those provisions of the settlement agreement on behalf of the trust.
Which is exactly our position, Judge.
Thank you.
So they're present. So if you look at the settlement agreement that was entered, that's drafted by Judge Klein on November 20th, and you look at the provisions of that settlement agreement, virtually all, with the exception of on page 3 where it says, in addition, Gordon, which is my client's father, will pay $5,000 out of his own pocket. The remaining provisions directly impact the trust. All of those provisions, if you were to accept the arguments that the trust was not present and did not have the ability to enter into the negotiations and did not subject itself to the jurisdiction of the court, all of those provisions would need to be set aside. So if you're setting aside all of those provisions, one of those provisions is that my client step down as co-trustee. So did his father shortly after the settlement agreement was entered. But if there's no jurisdiction to do those two gentlemen, and now my client serving in the capacity as personal representative of his father's estate, would have to be reinstated as the trustees of the Kevin O'Connell Trust.
In fact, they never would have been removed.
Or in fact, they could never have been removed. So if we're going to unwind that, we get to the unwinding portion, and you unwind it to its completeness. Mr. Rudisill and his clients aren't appointed as successor trustees. They're the successor trustees apparently pursuant to this agreement. They would then be unwound and would have no standing to stand here. They have to pick. They have to pick either it's an enforceable agreement and the terms are enforceable and the trust was there and the court had jurisdiction to enter in this agreement. And I'm going to give you a very simple example for this agreement to be enforceable, and that's with regard to Mr. Farrell. Mr. Farrell's a primary beneficiary. If you look at the agreement, was he present? No. Was he served? No. Actually, I'm not 100% positive as to whether or not he was served, but he clearly did not participate, nor did he appear at the settlement conference on November 20th, 2014, so how can he be bound? He's not brought in as a party. He's signed off eventually as he agreed to the document that was entered, and he signed off on the provisions of this agreement. So all four of the primary beneficiaries have signed off on the agreement. So now that's one bundle of rights. All the primary beneficiaries, if you look at this agreement, have agreed that this is appropriate as to them as individuals. They hold their bundle of rights. This is not something that the trust holds their individual rights in exclusion of them having their own individual rights. The primary beneficiaries have their individual rights, as do the contingent beneficiaries. So contingent beneficiaries were served. The notice of appearance was entered. Kevin Parker, Mr. Parker, showed up and appeared at the settlement conference and said, we aren't going to participate. We're not going to sign off. We're not going to enter into any agreements. So they took their bundle of rights, which is the contingent beneficiaries, and walked out the door with those bundles of rights. So the agreement that was entered into on November 20th, 2014 cannot and does not impact the contingent beneficiaries. But if it does not impact the primary beneficiaries and it does not impact the trust, the contingent beneficiaries are necessarily negatively impacted. So, for example, if you look at the 2015 complaint and the 2014 complaint, one of the very simple arguments that's being made is the current trustees, the successor trustees that are appointed, have brought an action to sue my client in his individual capacity or in his capacity as successor trustee for the total amount of $400,000. I'm sorry?
The client as a successor trustee?
My client was not the original trustee of the trust, so he was a successor trustee from Kevin O'Connell as well. So he's not the primary trustee. He was never appointed as such. He's a successor trustee, as was his father, and became such at Mr. O'Connell's death. Okay.
Thank you for that
You're
clarification.
Welcome. Sure. But there's lots of successor trustees, which actually brings me to the point where you can't just change hats and you have a new trustee and a new trust. It's not a new person. It's not a new defendant. It's not anything new. It's just who's driving the ship, so to speak, and who's driving that bundle of rights. So when you talk about the lawsuit that's filed for $400,000 additional to be sought from my clients in their individual capacity for the benefit of the primary beneficiaries because they didn't receive their distributions in a timely fashion is the allegation. They didn't receive their distributions and therefore they're entitled to interest. They're now putting the successor trustees that are here before you today, Mr. Luthold and Mr. Wiles, in the positions that the primary beneficiaries cannot be themselves. The trust can't bring a lawsuit for somebody on their behalf when they don't have those rights. The primary beneficiary gave up those rights. All four of the primary beneficiaries gave up those rights to sue my client, regardless of their capacity, whether it's in their individual capacity or in their capacity when they were serving as trustees, to bring that claim for $400 and change for interest that prior to their distribution for the amount that they've claimed. They waived that right. This is all claims known and unknown. That was clearly before the court in 2014. All four beneficiaries have signed off on that. So the negative impact comes like this. Mr. Rudisill is allowed through his clients to bring a case against my clients for that $400,000 to recoup that money for the trust to go to the primary beneficiaries and use trust assets to pursue that claim, whether they're successful or not. But they're using trust assets, and if there's not sufficient funds to pay out those the primary beneficiaries, it's a detriment to the primary beneficiaries. If there was sufficient funds, but now they've used those funds up to prosecute that litigation, the contingent beneficiaries get nothing. if that's used up for this purpose. My client is entitled to his attorney's fees for defending this action because it's because of his actions when he was serving as trustee that he's being sued. It's not in his individual capacity. Certain portions are, but those are the bundles of rights that were all before the court in 2014 when the settlement agreement was reached. So if you're going to allow the primary beneficiaries putting on a different hat and coming to this court and saying, we want to assert our rights, our additional rights that we have because we have a new plaintiff. This was not the plaintiff in the 2014 matter. While they weren't the plaintiff, they were still a party. The party was represented. The party was represented by the then trustees, Gordon Sr. and Gordon Keith Jones Jr. as the trustees of the trust. That trust must be bound. If you don't bind the trust, you can't bind the agreement on anybody and everything comes unwound.
Counsel, it's your position, I rather gather, that the 2015 litigation or case does not in any way benefit the contingent beneficiaries?
That's not my position at all, Judge. It does benefit the contingent beneficiaries.
Help me understand how their claims are barred.
Their claims are actually held by the contingent beneficiaries individually. So it's the contingent beneficiaries, based upon the agreement that was reached, having been placed on notice that needs to perfect those rights. It's not the trust's duty any longer because the trust entered into an agreement with regard to the claims that were brought to resolve those claims that the primary beneficiaries have made. So if the contingent beneficiaries believe that this is a strong enough case to bring, then they should have done so.
And your argument is that the successor trustee, the contingent beneficiary could have, but your argument, I rather gather, is the successor trustee could not have brought claims for the benefit of the contingent beneficiaries.
Sort of. I think it's probably most beneficial and cleanest if the court says, no, the trust is bound and let the contingent beneficiaries argue on themselves. But if the trust in this lawsuit was brought in a clean fashion, benefiting solely the benefits of the contingent beneficiaries, it would not have been a violation of the agreement. But that's not what's brought.
And I get that it's not that clean, but your argument is the entire 2015 petition goes away. And if you concede that a portion of that would benefit the contingent beneficiaries, why is that barred?
It's a balancing test, Judge, and here's why.
Whose balancing test?
It's a balancing test for the trustees to have made.
And
the trust, and so let me, because this is kind of where it gets a little bit tricky. So I understand that this is
I don't know that
odd.
it's that tricky. I just need it explained in a way so that makes sense.
Okay, so when you have a balancing test that's brought, the balancing test is done by who? The balancing test that's brought is done by my client and his father in 2014 as to whether or not to bring that case.
And that binds the beneficiaries.
Trust. It does not bind the beneficiaries, Judge.
So
it binds the
beneficiaries
trust.
then have the right to bring a suit.
Absolutely.
To challenge the handling or the mishandling of the assets of the trust.
Absolutely.
Okay, so I guess I'm not sure where this balancing test plays a part.
The trustees have a duty to all beneficiaries.
Absolutely.
Okay, contingent and primary. So when my clients entered into an agreement in 2014, they did so from their perspective because they've resolved their claims for attorney's fees. Those are open back up. They've resolved their claim to continue to serve as the trustees of the trust. They've waived their right to be paid a fiduciary fee for the time that they've inputted in managing these trust assets. Those are all very important rights that they gave up that they chose not to pursue for the benefit of all of the beneficiaries of the trust, as is their obligation.
But you're not suggesting that by engaging in the process and the determinations they engaged in, that they also spoke for the contingent beneficiaries when they did so.
I am absolutely not saying that. That's correct, Judge. The contingent beneficiaries, when they got up and left the settlement conference with their bundle of rights, those bundle of rights stay intact and cannot be pierced by what we're doing even here today.
Or what was decided in the settlement agreement.
Or what was decided in the settlement agreement. All of those things are there. But the trust is under no independent obligation or duty to perfect in complete disregard. So let's look at it as if we have $200,000 worth of assets, and you see what the distribution was. You have 600 going to one primary beneficiary, 5, and 5. So $2.1 million walking out the door in totality. If you have $1 million or you have a couple of $100,000, does the trust then have to turn around and sue the former trustees when there may not be any money to be had and use trust assets to the detriment of the primary beneficiaries and to the detriment of the contingent beneficiaries? The answer is no.
Isn't the question not have to sue, but can they properly sue?
Could they properly sue? Again, I think...
Because we're here
Sure.
on the argument that none of this could move forward, right? Not that, reasonable minds could differ and somebody was on the wrong side of the scale. Your argument is none of this can go forward, period. It stops.
Well, there's a double argument that I haven't got to yet, and I do want to be conscious of my time because I want to reserve some of that. The answer to the question is the trust is bound. The trust was bound by the former trustees, my client and his father. The trust is completely and totally bound, but it doesn't impact the contingent beneficiaries. They have full access to the trust, the assets that would have been wasted, and bring their entire claim and be made whole. They can't be made whole if the trust then continues to advocate on their behalf because they're going to spend trust resources to get there. So I think I'm running out of time, judges. I think I'm going to reserve what's limited that I have left for my rebuttal.
Thank you, counsel.
Good morning, Your Honor. My name is Kenneth Rudisil. I represent Bart V. Wiles and Clark Luthold, the co-trustees of the Kevin O'Connell Trust. May it please the Court, I've listened closely to Mr. Kupicheski. The resolution in this case lies in a single issue. The contingent beneficiaries, by admission, did not waive their rights, did not participate in the settlement agreement. Controlling authority says that a settlement agreement cannot affect the rights of a non-party, non-participant, non-signatory to a settlement agreement. We've admitted that the contingent beneficiaries are not. The divide that Mr. Kupicheski seeks is to say that the settlement agreement doesn't affect the contingent beneficiaries, but affects the successor trustees and removes their right to sue on behalf of the contingent beneficiaries.
Counsel, does the settlement agreement preclude the successor trustees from bringing suit against the prior co-trustees?
No. Statute actually is an affirmative duty to sue to recover those amounts. And here's the other thing. The Joneses can't release their own liabilities. They can't, on their own behalf, cause the trust to lose any ability to sue them. You can't release yourself.
Can the co-trustees enter into an agreement with the primary beneficiaries whereby they bind contingent beneficiaries that were not parties?
No.
So isn't it anomalous to say that that the trust can be bound in a situation where and sorry, but we throw these around so easily, we're binding as I understand your opposing counsel's argument, he wants us to bind the contingent beneficiaries by the conduct of the primary beneficiaries, basically for the benefit of the prior trustees when there are now successor trustees in place. Is that a fair statement?
I think that's the argument, but that argument is not effective. The primary beneficiaries have no right to bind the contingent beneficiaries. The court got it absolutely right when he said that the mutual release given by the four specific beneficiaries was to release the Jones defendants and the successors and assigns from liability for the damages they allegedly caused these four cash beneficiaries. That's all. And we agree 100%. The settlement agreement, we don't disagree with the settlement agreement. The settlement agreement says the primary beneficiaries can't sue the Joneses. We don't disagree. We do understand that there was an error made, and I did it, in preparing that complaint and alleging the damages based on the interest due to the primary beneficiaries. Arguably, at least, that's only to their benefit. But there's an additional $1.5 million claimed against the Joneses that don't have anything to do with the primary beneficiaries. They seek dismissal of the 2015 case because one single element of the damages might inure to the benefit of the primary beneficiaries, and that's just not possible. We can't dismiss the 2015 case because of that. And
But you agree, counsel, that to the extent the 2015 case seeks a remedy for on behalf of the primary beneficiaries, that's barred by the settlement?
yes, we must so concede.
Thank you.
However, we assert the balance of the additional $1.5 million is still collectible. All that could have been intended.
But only collectible, counsel, by?
I'm sorry?
But only collectible by whom?
By the co-trustees payable to the trust, and it will inure to the benefit of the contingent beneficiaries. The co-trustees by statute are to bring the cause of action on behalf of the contingent beneficiaries. They did so. Am I not clear?
Oh, I'm listening.
Okay. All that could possibly have been intended by this settlement agreement is that the primary beneficiaries released the Joneses and the Joneses released the primary beneficiaries. The conflict of interest under which the Joneses were operating forbids them from doing anything with respect to the trust or the contingent beneficiaries. Controlling authority says that they can't do that. The Superior Court's holding is correct, whether it's analyzed under the jurisdictional, and we offered the jurisdictional arguments, if you will, in order to try to demonstrate to Judge Klein, successfully, fortunately, that his initial reaction, his initial judgment was incorrect, because the Joneses did not appear in that case as trustees. They appeared in their individual capacity. They were sued in their individual capacity.
We're talking about the 2014 case.
That's the 2014 case to which I refer, Your Honor.
So they had no ability, if they didn't appear in their fiduciary capacity, they had no ability to utilize their fiduciary responsibilities or address their fiduciary responsibilities by binding the trust.
Correct. And to back it
So
up,
effectively, the settlements doesn't affect anybody.
well, the settlement affects the Joneses and the primary beneficiaries.
But not in regard to the trust. That the trust has no obligations.
I don't believe it has anything to do with the trust there, and the settlement agreement doesn't suggest that it does. Mr. Kupachesky suggested to you that Mr. Jones paid $5,000. He, in fact, paid $20,000 out of his own pocket, and $200,000 came from somebody who was not even a defendant in the 2014 case, and that's California Supreme Salt. We won't get into why. I don't think that's a matter of the record in this case, but no damages were sought from the trust. The damages were all sought individually from the Joneses.
How then does the settlement agreement affect the scope of the relief in the 2015 case, which you've conceded is solely with respect to the contingent beneficiaries?
Yes. I'm not sure of the question, Your Honor.
How, if that's what the settlement agreement is and does, to follow up on Judge Jones's question, what limiting factor, if any, does it have on the 2015 case? Because I thought I heard you to say that the 2015 case could only seek relief for the benefit of the contingent beneficiaries, given the settlement agreement. But I just heard you say that the settlement agreement is only with respect to the primary beneficiaries and the predecessor trustees as individuals, not as trustees.
Yes, I do believe that's the case. In the 2015 case, the damages there assessed cannot be collectible, but that's an issue for the court in the 2015 case. It's no different than if I suggested that some outlandish damages that don't relate to the case were due and payable. The court will say, no, they're not. And so all they have to prove in the 2015 case is that these particular damages were waived or released.
And again, what's the scope of the settlement agreement under your view of the world?
The scope of the settlement agreement is a release between primary beneficiaries and the Joneses in their individual capacity.
And so that would or would not affect the claims in the 2015 case?
To the extent that the claim we made was for interest payable directly to the primary beneficiaries, it would bar those damages.
Okay. How about interest indirectly payable to the primary beneficiaries? Still barred?
Yes.
Attorney's fees, costs, anything for the primary beneficiaries?
Yes.
Still barred?
Yes.
By the settlement agreement?
Yes.
Any claim that remains viable in the 2015 case with respect to the primary beneficiaries under your view of the settlement agreement?
Yes, I agree.
And so there's none left viable?
No, the primary beneficiaries are out of this case. And I don't know that I should say, but we're arguing here about something that doesn't exist. It's not in the record, but the primary beneficiaries aren't even part of the trust anymore.
But they could stand liable against the contingent beneficiaries in the case
Primary beneficiaries wouldn't be liable to the contingent beneficiaries, I don't believe. I'm not sure what theory that would be.
So any waste or mishandling of the trust assets that went along, that occurred during the time that the contingent beneficiaries were contingent beneficiaries and they had a reasonable right, an absolutely understandable right to believe in the total value of the trust, if you will. And there was something that was done with assets during that period that they believed, and I'm just talking theoretically at this point, that they believed in theory would have impacted their take down the road. They couldn't go against them for that because of the settlement in the prior case.
Well, no, I don't believe the contingent beneficiaries are barred as vis-a-vis the primary beneficiaries. What I believe is that if the contingent beneficiaries had a claim for waste, that claim would be against the trustees who committed the waste.
That's exactly my point.
Not against the primary beneficiaries.
But if they were the trustees, that were asserted to have engaged in the waste, but since the contingent beneficiaries weren't made parties to the settlement,
they should have a right of action against the Joneses for waste if the Joneses laid waste.
And they were the original trustee, or they were the co-trustees.
The original successor trustees.
Yeah. There's no limit to the amount of confusion that can be read
Exactly.
into the terms in this case. All right, thank you. That answered the question. Thank you.
Sure. Let's get to the service of process here. Well, we've covered it. I don't need to go further on that. Also, some of what we're arguing here would have relevance if this were a judgment. It isn't. It's a non-judicial settlement agreement that was approved by the court. The settlement agreement is not a void.
And you're not suggesting that it could be enforced against non-parties before the court, not before the court.
No, it can't be enforced against non-parties, but it's not void, is what I'm saying. That to Mr. Kukaczewski's argument that everything gets unwound and the Joneses are still the trustees, that's just not true. Not under the law. They are in the briefing. They argued that Rule 9 somehow conferred jurisdiction. We've cited two cases that tell you that Rule 9 is not jurisdictional. This whole motion to enforce the settlement agreement founders on the fact that the contingent beneficiaries didn't sign the agreement, weren't part of the agreement, and didn't waive their interests. All of the rest of the arguments here, nothing but surplusage. If we don't have any more questions on these issues, I'll move to the cross appeal.
It's your call, counsel.
Okay. Judge Klein, and I mean no disrespect because I have the ultimate respect for Judge Klein, did err, however, when he said that there were competing attorney's fees statute that precluded his awarding Mr. Wiles and Mr. Luthold, the current co-trustees, attorney's fees on the petition to enforce. It's clear that the petition to enforce dealt with a settlement agreement that's a contract and should give fees under 1203-4101. However, ARS 1411-004, which gives fees to a trustee, which fees arise out of and relate to the good faith defense or prosecution of a proceeding involving the administration of a trust, it does not lie in this petition to enforce. There is no evidence of good faith, and the petition to enforce is not a proceeding that has anything to do with the administration of a trust, nor this 2015 case that they're seeking to dismiss. That's clearly a case that targets the Joneses as individuals.
Counsel, your client's fee request is based solely on 12-3-4101, correct?
That's correct. It would lie on 1411-001 or 004. We didn't allege it because we didn't want to confuse the issues. In sum, the Superior Court's conclusion that competing statutes preclude an award to the successor trustees is incorrect as a matter of law, and therefore an abuse of discretion should be reversed and remanded for proceeding on those attorney's fees. I have nothing further unless there are questions.
Okay, thank you, counsel.
Thank you. Judges, you've heard a couple of things here on the arguments that have been entered, primarily of which you haven't heard anything with regard to the settlement agreement other than what was identified in a slight correction when I spoke and said $2,000 or $5,000 was paid out of Gordon Jones's pocket directly. It was $5,000 per primary beneficiary. Other than that, the entirety of the settlement agreement is with relation to the trust. Every single term is in relation to the trust. Counsel's admitted that this portion, or the settlement agreement, binds the trust in that Mr. Luthold and Mr. Wiles are now the successor trustees. How can that be if they're not a party to the agreement? So the trust is there. The trust is bound. The trust can't be bound by a little bit. So let me give you an example. If you're, and I alluded to it earlier when I was making my arguments as well, but it's more important now. If there's not sufficient funds to pay the primary beneficiaries their money, or there's no additional funds to satisfy the attorney's fees that are out of the litigation, that are spawned out of the litigation brought by these new trustees, Luthold and Wiles, the primary beneficiaries are actually liable. They're actually liable because there's been a distribution that's been made to them. Counsel just told you that there's been a distribution and they no longer have an interest. But they have responsibilities. If the trust has overextended itself and paid administrative expenses that they don't have the ability to recoup, the primary beneficiaries still have liability. That's why.
Fiduciary breach. Is that what you're saying?
Not as a fiduciary breach, but if the fiduciaries that are in place now, Mr. Luthold and Mr. Wiles, if they have fiduciary expenses for the administration, let's say that they bring this, let's just assume argumentatively that the case that they brought in 2015 is brought in good faith and solely for the benefit of the contingent beneficiaries, and they lose. They're entitled under 11-004 for their attorney's fees if the action was brought and prosecuted in good faith. If they don't have enough money to satisfy this action, they get to go back and disgorge the money that's been released and given to the primary beneficiaries because there's insufficient funds to pay that obligation. The trustees are not bound, and they don't have to come out of pocket if they lost an action that they brought in good faith. So if they've distributed money, there is the possibility that they're going to get disgorged. So the trust has to be bound. You can't have it both ways. You have to pick. If you're bound, you're bound. If you're not bound, you're not bound. And if you're not bound, this whole thing comes unwound. That's the danger that the arguments that are being offered by Mr. Leuthold and Mr. Wiles present to this court.
Counsel, let me ask you a hypothetical.
Sure.
Hypothetical, right? There are 10 beneficiaries of a trust, one of whom sues, and they reach the settlement agreement with the same terms as the settlement agreement here. And then beneficiaries 2 through 10 decide to sue, or actually a successor trustee sues for the benefit of beneficiaries 2 through 10. Your view is they're out of luck, right?
No, it's not. It's not my view at all, Judge. The beneficiaries 2 through 10 can still sue.
Now, remember, my hypo was the successor trustees.
The successor trustees. Change the factor just by one, and it will become very clear to you. Change the factor that the trustees are not removed as part of the agreement.
And?
Who would bring the lawsuit?
I don't
It has
know.
to be the successor or the contingent beneficiaries. That's who's left. That's who. The only people that have a bundle of rights left is the contingents.
Is that as a matter of waiver of contract law, or as a matter of practicality, there's a breach of a fiduciary, it's just there's nobody currently to enforce it?
But there would be somebody currently to enforce it, the contingent beneficiaries, Judge.
But again, setting aside with respect to the trust, if you don't have a successor trustee, is it that the claim doesn't exist, or you just don't have a trustee to press it?
Judge, I'm out of time. I'm happy to answer your question if you'd like.
Please.
It's not a question for the successor trustee to pursue because the trust is bound. The trust has been absolved by the agreement with regard to the trust aspect. If the contingent beneficiaries believe that that was done inappropriately, they have all of their bundles of rights to bring it to the
So
court.
let me play it back.
Sure.
So in my hypo, and again, it's a hypo. I'm
Sure.
not saying it's this case. Beneficiaries 2 through 10 would have a claim, but a successor trustee could not sue for the benefit of beneficiaries 2 through 10.
I think as a legal matter, the answer is that's correct. If you're binding the trust in totality.
And your position.
So, and you have to weigh it in the totality of the circumstances of the settlement, because if it's just with regard to one particular trustee, you probably are not removing that person as trustee. But if there's all these other things that are coming into play, which is clear from the settlement agreement that's been entered, they're not seeking trustee fees, they're not seeking attorney's fees as part of that agreement for the time that they would be entitled to those fees to resolve the claim to bind the trust. The trust is stuck. The only people that have any rights that emerge from that settlement conference on November 20th is the contingent beneficiaries, and all of their rights must be maintained. Judges, if you are giving us that the primary...
I understand your position.
All right.
Let me follow up with one. Are you then saying that the successor trustee remains in place, but because of a prior settlement agreement that he had no part in, he is precluded from bringing lawsuit on behalf of the contingent beneficiaries by something he didn't have a part in, they didn't have a part in, and somehow the contingent beneficiaries are just on their own?
That's exactly right, because the contingent beneficiaries do not have an independent right outside of what exists, and I'm sorry, not the contingent beneficiaries, the successor trustees do not have an independent right that doesn't exist outside of the trust document. So if the preceding trustees have bound the trust, they're bound by those decisions. So they bound the trust because they were parties to the settlement agreement. So everybody's there making that agreement together.
So we're real clear.
Sure.
The contingent beneficiaries are bound by a settlement agreement in that they cannot have the successor trustee pursue their interests as he is obligated to do. He has a fiduciary obligation to do, right?
The trust is under no obligation really to do necessarily anything that they don't evaluate to be appropriate. So judges, if you're giving us the decision that the primary beneficiaries are to receive nothing going forward on this, and it's only the contingent beneficiaries that have any opportunity to bring a claim, that's something that's always been identified, that the contingent beneficiaries have that right to bring that case. But if you don't bind the trust to the agreement, everything comes unwound, and my client still would have a right to seek remuneration from the trust for their service, for their attorney's fees prior to that agreement being entered. It wouldn't exist otherwise. The agreement can't be there.
Thank you, counsel.
Thank you.
Not exactly one of the clearer areas of law. We appreciate your argument. We appreciate the addressing the cross appeal as you have. We're going to take the matter under advisement at this time, and we do appreciate the time you spent with us today, and we will render our decision in due course. Thank you.